Welcome to the Jones Zone, a podcast by Darryl and JJ Jones.
Hope you enjoy this episode. Make sure to subscribe and follow us for similar content. We have videos explaining escrow, title insurance, how to get top dollar for your house, mistakes sellers make all the time, how to evict a bad tenant, and so much more. Hello, everybody. Welcome to another episode of the Jones Zone. Live from Davos, Switzerland, we've got John and Walt Tamulinas. We're going to talk about things that sellers can do to protect themselves in a transaction, along with all the new laws, or some of the new laws and rules and regulations that were passed that are coming in effect here in 2026. A lot of things that are, I guess I'm not supposed to say how silly they are, so I won't. I need to start off with saying, hey, this is not meant as legal or tax advice. Listeners are directed to verify information with their own experts, such as attorneys, accountants, brokers, etc. So take that for what it is, and I appreciate you joining us. So Walt and John have been in the industry. Gosh, we've got probably, almost 150 years or maybe 125 years.
Combined with the three of us, right?
Yeah, of transactional experience right here. Walt, you represent the buyer or the seller in the Louisiana purchase?
Both.
Oh, you double into that one.
Yeah.
I didn't even know you spoke French. That's good for you. All right, so let's talk about what are the most common mistakes sellers can make that would increase their liability? Because I know this is a big deal. Meaning, you want to avoid lawsuits. That's part of what our job is, to try to reduce the chances of lawsuits as much as possible. What are some of the biggest mistakes, Walt, that you're seeing out there?
I think we're going to cover both, too. Mistakes that sellers make and mistakes that buyers make, because they both, fumble the ball once in a while. So, one of the things is they forget about the repairs that they made. And these repairs might have been made years ago, but they're critical issues for a buyer to know about if they did something major on the house.
And this always surprised me. So, for example, if they fixed a broken window 4 years ago, got the window replaced, they need to disclose that.
What do you think? What do you think, boss?
I think so. I think one of the biggest things for sellers right now is to slow things down. I mean, when you're in the middle of a real estate transaction and your real estate agent dumps a 1-inch stack of disclosures on your table, and it's daunting. It's like, where do I even begin? So I think from an agent standpoint, they need to get the disclosures to the seller immediately when they're taking the listing. And the seller really needs to slow it down. There's a form in there. It's the Disclosure Information Advisory. They need to look at that. That right there outlines exactly what they need to disclose to the buyer. So really slowing it down, filling those things out. And don't do it in one day. I mean, I've owned my house since 2005, and it's an evolution, right? So you got to really take your time. Get the disclosures. It's probably going to take a week at least to fill these things out if you've been in that home for 10, 15, 20 years. And then when you're done, talk to your agent. Say, here's what I got. And maybe the agent can sit down or take a walkthrough through the property and really dive in and say, okay, let's make sure we covered everything. Because the last thing you want is, you have it's been raining a lot in Southern California. We got mold, we got water intrusion, we got leaky roofs. The last thing you want is for them to forget about the roof repair they made. They close escrow, they move in, and the neighbor comes by. They bring that goodie bag or that introduction, and they have a roof leak 2 weeks into moving in, and the neighbor says, "Oh, by the way, did they tell you about the roofer that was up there a couple weeks ago?" And the answer is always no. So the seller at that point.
And that's a common occurrence, neighbors.
We'll
talk about that.
Yeah, we'll talk about that. We'll get to that part, what happens in that. But there's also insurance claims. You make an insurance claim and you forget about it. So they always make sure that they disclose those things. A lot of times it's flood and the water can cause mold, which is the hot button these days. And then there's disclosing these neighborhood nuisances. People don't realize they have to talk about that. We've had issues with dogs barking.
Chickens. Didn't we have issues with chickens?
It never ends. So there's 3 Ds: dogs, drunks, and drugs. So you got to disclose all those. And so if there's an issue in the neighborhood, you've got to talk about it. Some guy's running naked through the neighborhood. You got to make sure everybody knows about it before you close the escrow.
Is there a lot of turnover where you live?
Anyway, it is important though to remember those things. And John's right. Take your time. Don't rush that. Take it slow. And what was the form you named that
DIA, the Disclosure Information Advisory?
That's huge.
Very critical.
Right.
Very critical.
I'm glad we got that.
And that's one everybody should read together so that they know exactly what it is they have to disclose.
And one last point, I think, for a seller, if you're going to take anything from this, is really you have a buyer already, right? The buyer brings these issues to the table. I think in a lot of cases, if the buyer is not going to be extreme in their ask, it's better to work with that buyer. Why? Because you now have a new disclosure. You now have all these facts. The buyer is asking you to fix it. If you can negotiate with the buyer and make it a reasonable negotiation or a reasonable outcome, it's better to work it out with them, because you're going to have to start all over. If you start all over, you're going to have to find a new buyer. You may not get the price you want, and you're going to have to take all this information that you've learned and pass it on to the new buyer, and you're going to have to cross that bridge with that new buyer at that point in time.
I know what you're talking about, but let's fast forward for the audience. We're talking about oftentimes whenever you sell a house, it's subject to the buyer's home inspection, typically is where these things are found out, along with the disclosures, and they normally find something out. I mean, whatever it may be, something that may be minor or major. And at that time, oftentimes the buyer will come back with what's called a request for repairs or ask for credit. And so John's talking about that. When that comes up, and yeah, I would suggest that it is oftentimes best to try to work it out with that first buyer. But we oftentimes will have a backup buyer in place just for that, to kind of protect against that. A little insurance policy, meaning if the buyer does get, because sometimes buyers get a little crazy, and they'll ask for $200,000 for a broken window. It's not $200,000, but in any event.
Yeah, everybody wants the house while they're bidding against 10 other buyers. And then when all the other buyers are gone, they say the ether's gone. And so then it's like, okay, let's negotiate again.
Yeah.
So you have to be prepared for that.
We're seeing that a little bit more and more. What's the best way to protect buyers and sellers from liability after they moved out, after the close?
Well, we talked about it a little bit in the beginning there, and it's disclosed. There is no such thing as over-disclosing. When they ask the question, do I need to disclose this? The answer is always yes. It is always yes.
That's funny. I think you'd mentioned that to me a while back, is if the question's asked, then it's a yes. Kind of a good rule of thumb to use.
And then timing, the earlier the better. Let's not wait for the last minute to say, oh yeah, I got to tell you about this. It's always good to tell the last minute thing if you forgot about something, but it's really critical to get it out there early so that the buyer knows. The shock can get done right away up front. You don't want to wait until the bad news, 30 days into the escrow. You want to get it all out there as early as you can.
And another reason, though, for that is because then the contingency time periods start over again. But go ahead, I'm sorry.
And then we never want to hear this. We told them, the agent was there, and I told the buyer that's not a disclosure.
Verbal.
The only way you can do a disclosure, it has to be in writing. Talking about it doesn't make any sense.
And you have to have the buyer sign for it. Period.
What do you
Email
mean?
is okay. Sending an email is one thing.
Oh, in other words, okay.
You got to have the buyer sign that you made that statement.
More specific, in writing on a document the buyer signs.
Correct.
Yeah, not just a text or
Right.
just to clarify. Yeah.
I say all the time, to memorialize our conversation, blah, 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 and if this is not the way you understand it, please let me know and respond to this email. So you put it out there, and just, everybody talks about it. Buyers and sellers get together during these walkthroughs, during inspections, and, oh yeah, I told them. That doesn't work. No bueno.
Yeah. All right.
One other thing on that, Darryl, one of the biggest things, we talked about this in our legal update with our attorney, is repairs after the close of escrow. So the way the contract reads is the seller, if they're going to be doing any repairs, those need to be done 5 days prior to close of escrow, so that the buyer can go in and do their final verification of property condition, make sure that these repairs are done, and they're satisfied with those repairs. So leaving repairs, tenting, a lot of times people do the termite tenting after the close. What happens if they damage the roof, broken roof tiles, or something can happen? You never know. Really don't do any repairs after the close of escrow. From a seller standpoint. From a buyer standpoint, you're representing the buyer. Make sure that's not done. Make sure these repairs are done before your buyer owns the home, because a lot of times they get in and start doing a repair, and they start finding other items, and the list goes on, and the cost goes up and up. And we all know the cost goes up 10 times after the close of escrow, because there's no leverage, there's no way to negotiate it at that point in time.
Walk us through, how does a seller make a proper written disclosure?
Well, there's two documents that come in the beginning of the escrow. One is called the Seller Property Questionnaire, and it's 3 or 4 pages long, and it reminds them of all the things that could be a problem that they need to disclose. It's a really good document created by the California Association of Realtors. And then the other one is a transfer disclosure statement, which basically says, my sprinklers don't work, my oven doesn't work, the gate's broken, and it gives the opportunity to talk about all the things that are flaws in the home.
Yeah, so it makes it a lot, because oftentimes it's overwhelming. People think, I can't remember every little thing. And this questionnaire kind of jogs the memory. It asks you specifically any problem with lighting or whatever, electrical or things like that.
So the two things about the two forms we talked about, the SPQ, the TDS, the most important thing when filling these out from a seller standpoint is to make sure they coincide. Remove any ambiguity. Only state the facts. Okay, material facts are what you're putting on there. No, you're not taking inventory.
Oh, I want to touch on this because our attorney a few
Right.
years ago had a great comment. In fact, I think we did it in that restaurant. Anyway, the attorney put on the wall, small settling cracks in driveway. And he says, what's wrong with this? A room full of real estate agents go,
Right.
nothing, everything looks great. It's like, no, small is subjective. You don't need to put small or big or medium or whatever.
And how do you know it's settling, Craig?
And he says, how do you know it's settling? When did you all become geologists?
Right.
And so just cracks in driveway. So with that, you don't want to be too many adjectives. What would be the fair way to say
No
that?
descriptive adjectives.
There you go.
I mean, if you see a stain on the ceiling, stain on the ceiling. You don't say it's mold. Don't say water stain. Don't classify it. But my point in the SPQ and the TDS is those things.
SPQ, what's that stand for?
Seller Property Questionnaire.
And TDS stands
Transfer
for?
Disclosure Statement.
Okay.
Okay, those two documents, if you say yes on one, it has to be yes on the other. If they're conflicting, then you have a problem. You have to address that issue.
And where the problems happen in these forms is people want to be narrative. They want to give a little paragraph explaining, and it's better not to do that, The fence broke, we fixed it. That's better than going into all the details about, they had to split it with a neighbor, and none of that matters. It's just the less is more when you're writing on these forms.
So what are some of the common mistakes that buyers make that creates liability?
Well, we ask them to do a physical inspection and hire an outside company that does this all day long, every day. They're experts in this area.
And that's a guy it's like a mechanic, a house mechanic. He comes out there, a home inspector. He typically looks through the entire house. He's there for a few hours.
They're going to kick all the tires. They're going to take a little device and stick it in each wall outlet to see if the ground fall interrupter, whatever that is working properly. And so they really do a thorough inspection. And the cost can be $400 to $1,000 depending on what they do. And one of the nice things they offer too, by the way, is that they offer an estimate of what it would cost to fix all that stuff that they find wrong. And there's pages and pages and pages of things that are wrong with every property. There's never an inspection that says, nothing's wrong, this is perfect. That just doesn't happen.
Yeah, that's for
so
sure.
that's a critical issue. And the buyer says, no, I don't want to spend the money, I'm not going to do it. So really a critical issue to have a third party, disinterested person going in, checking everything, all the systems of the house. From the roof to the plumbing to the electrical, they look at all of it. They open the boxes, they look at everything. And the other thing is not checking permits. The buyer really needs to see what's going on at the city. Especially in older homes, you'll find a family room added on. Did they get it permitted? The lender is going to find that out, and you're going to know that's a problem as soon as the lender gets involved in this. But what happens when you try to resell the property? I'm going to take the room without a permit. That's no big deal. What happens down the road when you try to resell it? Is the next buyer going to take it like you did? And then
The lender doesn't always find that out. I mean, not that we keep anything from a lender, but they're not always checking on permits. At least that's been my experience.
you definitely want to know whether there's a
But the
permit or
buyer
not.
should know, yeah.
Right.
It's on the public record. I mean,
Yeah, yeah, absolutely.
And there's a lot of pressure in the transaction from all the parties to have the buyer remove their contingencies. I think the contract default is like 17 days.
Yeah.
And so, if they get a slow start or they don't have access to the property, sometimes they might need a little bit more time. Let's take the example where you have a 30-day escrow. I mean, oh my gosh, you have no time to do anything. You don't have time to breathe. So, everybody's hurry, and then we miss things. And so it's better just to slow it down, give the time that we need. Don't remove any of the contingencies until you're ready to move the contingencies. It doesn't matter how much pressure there is. You need to follow the steps to check every box so you know exactly what's wrong and you know exactly what you're buying. Slow the process down and check all the boxes.
So the thing, another mistake that they make is when they do the inspection. That's one thing. It's great. They kind of have a broad overview of what's going on with the house. But a lot of times the inspector will mention, hey, I recommend the roof get evaluated by a professional.
Yeah.
So if you're worried about the roof, or you see the roof and there's broken tiles and the inspector calls it out, the buyer really should have that roof inspected.
Yeah.
Or if you have slow drain, the drains are slow to drain, the water's pooling up. You got to get a plumber out there to determine what's going on with this thing. I mean, camera the drains. But really the home inspector is going to make those recommendations, and you don't have to inspect every single component, but if there are major red flags and the inspector says to do it, you're better off doing it versus buying a home and
Getting a
paying more
specialist
later.
out there for a particular item.
Right.
Especially on the big things. The little things, not so much, but the big, like the roof, the plumbing, the electrical, those are critical issues. Those are expensive fixes if you have to do something later on.
Right.
The foundation, that's another one.
So understanding what you're buying. I mean, you're buying the home. You have these repairs that need to be done, but you got to get an itemization on what is it going to cost me after I close escrow to get these things fixed and livable, right? I mean, you can ask for repairs. You can ask for the seller to do the repairs, right? You can ask for a credit. You can say, hey, I want credit toward my closing costs, right? Or you can ask for a price reduction, or you can ask for a combination of each one. But the buyer should know, and the agent should really guide them to find out what is it going to cost you, because you don't want to close escrow and find out it's going to be instead of fixing the roof, no, it needs to be replaced, and now that's a $50,000, $40,000,
Right, and I prepared the clients for multiple negotiations. When you get into, you get the price settled down and the terms settled down and how long the escrow is going to be, and you open the escrow and you're settled. Then you have to do another negotiation after the repairs come in. If the repairs are major, the buyer's going to expect some sort of compensation or some sort of change in the contract. And so I think it's good to prepare the clients in advance to say, look, there's going to be another negotiation after the repairs come by. And you have to prepare the buyer in advance, especially if they win over 10 or 20 other buyers. They have to know that they can't be too, asked. They can't ask too much, when it comes to the physical inspection. They've got to be reasonable because they won and everybody else lost. The other thing I wanted to talk about was a pet peeve of mine is there's this document from the title company called Statement of Information. And it's very basic. It's a simple one page. It says, some of them are 2 pages. It says, this is my social security number. This is where I've lived the last 10 years. This is where I've worked the last 10 years. And the title company puts this into a database that does a background check. And it searches for all the liens that are against these people because they've got to insure the title for the lender. And so this document doesn't come back with the escrow instructions sometimes, and the buyer waits till the last minute to fill that thing out because they don't understand it or they have questions.
This is a buyer fills it out.
Right, right. And so both parties fill it out so they can check for liens on the property. And so we want to know that stuff up front. You don't want to go into a 60-day escrow and find out that somebody's got a lien for child support or an old debt they didn't pay off and there's a charge off and somebody's got a lien out there. And a very common one is tax liens. Those things sneak up on us all the time. So this statement of information needs to come the first week that escrow is open. And they've got to get it in because then you ask the title company to do a date down, and they do the search instead of at the end. They do the search in the beginning to find any boogeyman that's in the closet there.
Yeah, good advice. Now you mentioned, and let me go back a little bit, a CLUE report. I think that's an acronym. What does CLUE stand for?
It's for insurance purposes. It's the background on the home. So if somebody makes it's like a credit report for the home. If someone makes an insurance claim, then it's on the CLUE report. And you obtain that through the insurance company. So that's another one. I'm glad you brought that up because it's harder to get insurance these days.
It's much harder
than it is to get a loan. You live in a house for 30 years and 20 years ago you had a leaky roof and you had some problems, so you made an insurance claim. You might forget about that. But if you look for that in the very beginning while you're shopping for insurance, you're going to get that out, so it can be a good disclosure. Oh yeah, I forgot about that one. Let's talk about that.
Yeah, and insurance, that's a big deal.
That's a whole nother topic, isn't it?
We used to ask for insurance 2 days before we close. Now we do it 2 days before we open escrow.
Well, now insurance is it's standalone contingency. You have 17 days to get insurance bound.
So what should buyers know about the change of ownership form? Tell us about that.
Well, let's talk about what that is. That comes from the county, and the county says, what are you doing with this transfer? Is it between family members? Is there an estate involved? And so both parties fill this out, and that's what creates the new assessment or the reassessment for the property. So it's called change of ownership form, and it's through the county. And it's, of course, anything that comes from a government agency is very complicated. So, you have to make sure to ask questions about what you're doing in the form. Ask the escrow officer, ask your agent to help you fill it out. And Darryl, there are so many different scenarios that it would take all day long to tell you all the things that could go wrong with that form. But if you want your property tax to be correct, or you're in a period where you're exempt from a property reassessment, then you want to fill it out properly. So you get the help from the title insurance company, you get the help from the escrow company, and you get the help from your real estate agent. Make sure you fill that thing out properly.
Name some examples. I think people might want to know this. When they would be exempt. It's a refinance, obviously.
Between family member transfers.
Okay, if they have proper
exempt.
paperwork also done with the county.
Right. Between family members, yeah.
Right.
So a mom and dad might be selling the home to their kids, and that would be exempt. So direct or in the descendant line. So again, they're all so unique. You have to be careful that you fill it out right. It would be impossible for us to discuss all the possible scenarios, but there's trouble when it gets reassessed and it shouldn't have been reassessed.
Prop 19's changed a lot. The legislators are after your money, but. Anyway, go ahead.
The trouble with reassessment is the county. The county, a lot of times, they can be 6 to 18 months behind. So the seller, they get this tax bill, a year and a half after they close escrow, and it's because the county's so far behind. A lot of these happen with trusts. So the trust will get reassessed, and the owner gets this bill out of the blue, and they call the agent, hey, what is this?
Yeah, let's delve into that a little deeply, real quickly. So your folks buy the house 30 years ago for $200,000. They got this low tax rate. Unfortunately, they pass away in August, and then it gets reevaluated at August value. So let's say it's worth $1.3 million then, and then so they're supposed to be paying taxes based on $1.3 million from August, but the county is so far behind that they don't even they figure out the amount until the following June.
Right.
And then you have this tax bill that can be a surprise. It's typically not huge, but it's something, right? Just to hopefully that makes sense.
So that brings up a good point. Whenever there's a death in an estate, you always need to go get an appraisal done. And I don't mean a formal appraisal where you pay a fee appraiser to. You can get an agent.
I do dozens a year for people for free
because then they establish the value. And if you have an argument with the county later on, and they're saying, "Oh, the value is $1.7 million," and you had an appraisal of $1.2 million, then the reassessment is much, much less. Yeah. And so you're in your example. Ma and Pa bought this house many years ago, and their tax bill's $200, and they die, and the value of the property now is $1.2 million. Well, between the time that they die and the time that you sell it, there's a reassessment in there, and so you want to be sure that you get the right value on that.
Yeah, in fact, I want to mention I do that for free for many clients. So anybody that needs that, let me know.
That's a great
just
service.
Email me or text me either way. Give us some stories about, you mentioned earlier about some problems after the sale. Oftentimes a neighbor comes up with something that the seller just forgot or whatever. You got some more stories that you can share?
So I do. Somehow the neighbors always know everything that's wrong with the property that the buyer purchased. So we had a situation where we represented a seller. This was a successor trustee. It's being sold in the name of the trust. The seller was out of state, back east somewhere, and we closed escrow. Right. A week later, the neighbor came by, and she proceeded to the backyard and took the hose and started filling up the pool with water. And the buyer happened to be home. He walked out in the back. He said, "Ma'am, can I help you?" And she said, "Well, I'm just here to fill up the pool." And he said, "What do you mean?" She said, "Well, the seller didn't tell you the pool was leaking? And he asked me to come fill it up once a week because it's down about a foot every week." And at that point, obviously, the next thing we got a call from the buyer. The buyer wanted the pool fixed, and long story short, the seller paid to have that repair done. I think it was right around $10,000.
Yeah.
And then how about the neighbor that comes over and says, "Oh, did you know that one of the family members died in this house?" It's something you have to disclose.
But deaths are, just to make sure it was where the California state or the law is, if there's been a death the last 3 years, if there's been a death prior or longer, further back, then correct me if I'm wrong, if you're asked, you can't lie about it. So, for example, there's a death 5 years ago. You don't have to disclose that. But if you're asked, hey, has there ever been a death to your knowledge, you have to say yes.
I guess there's another word in there, and that is, was it a violent death? You know, then there's categories of that. So that's something to look into. If there's been a death on the property, then we should talk about it, and it should be, maybe in most cases, it should be disclosed.
Yeah, that could be challenging depending on the type of death. I've come across a lot.
One of the exemptions is if the death was of AIDS, you don't disclose that. Yeah, I'm not sure why that's different than any other death, but and then there's, you know, mom and dad passed away. Where was it? On the property, or was it in the ambulance, or was it at the hospital? So that's a critical issue. It has to be disclosed. There are people that will not buy a home because somebody died in it. So it's a critical issue too.
And on that note, it's on the property, meaning if they're, okay, I don't want to sound weird, but if they're from the front door to the ambulance and they pass right there, that's still on the property. They don't have to be in the house.
That's right.
It's
That's right.
disclosed on the property.
If it's outside on the street, you're okay.
So you got to look for those little markers.
It's always on the death certificate.
For watching. If you liked the video, please subscribe for more.